This meeting will come back to order. Witnesses are reminded they're under oath. And Ms. Druber just missed to get, hopefully she's going to come back, but she had asked you if it was your policy to approve the protocol to board members within 24, 48 hours. You said no, it was longer than. She asked specifically about this one, but on your testimony before the committee, the record should reflect on page 27. Question was, you tried to do this once it, being the protocol, goes to the board or board members turn it around and make a decision within 24 to 48 hours. Is that correct? Your answer was right, yes. So,
yes.
Go ahead.
Yes, I checked into that. Again, I'm new to the company. I've been there 5 months. And
well, you shouldn't be new to the truth. Either it's yes or no. I mean, you have your testimony. I'm sure your attorney has it. You should just a caution, that's all.
Yeah, I was not intentionally telling.
I didn't think so.
Okay.
Ms. Christensen for questions, please.
Thank you, Mr. Chairman. And this is one of my first hearings on the institutional review boards, and I'm really shocked at some of what I'm reading and hearing. And I'm concerned that the IRB can be listed and then utilized by researchers without the Department of Health and Human Services even having to do a cursory check, and that if federal funds are not involved or an FDA-regulated product is not involved, there doesn't have to be any federal oversight of research, if I'm understanding correctly. And I also would wonder, listening and reading, if there should even be private for-profit IRBs. Maybe they ought to be university-based or somehow more directly under the purview of the department. My first question, I'll begin with you, Mr. Duber. When the committee staff interviewed you last week, you acknowledged that your company did not verify the physicians leading these experimental studies were real or that their credentials were accurate. In fact, when the GAO submitted its fake protocol to your company, you didn't verify that Jonathan Kruger, the person listed as the primary clinical investigator, in fact had a legitimate medical license. Is that correct?
Well, yes. What we did was we have never had the experience of having a fraudulent group of people lying to us about their existence and about their licenses. They did submit a license copy, but it turned out to be fraudulent too. So what we've learned from this is we need to start checking that, and we've changed our SOPs accordingly. But we did, in our review, what was required by regulations, and regulations do not require that be done, but regardless of whether it's required or not, we are doing that now.
So, but you did eventually, once you were asked to testify, check on the doctor. How long did it take for you to make that determination?
Well, of course, this whole thing didn't come up until I got the letter from the subcommittee on the 23rd of February. So sometime after that, a day or two after that, we started checking into.
Was it a long process to check to determine whether he was?
Well, actually, the date that sticks in my mind where most of the work was done was March 5th, and it took us, a team of us, about maybe 3 to 4 hours to check all these things out. The existence of the company, which didn't exist, the phone numbers, the licenses, and all that. It took quite a bit of time to just go and.
For all of it, but probably checking to see whether the doctor was a duly licensed physician.
No, that doesn't take long, and that's why we're, that's a prime example of why we're going to start changing that and start doing it.
Mr. Kurtz, let me turn to you. You submitted a fake medical license to Coast IRB on behalf of Dr. Kruger. I think it's in the binder that you might have there. It's tab 2. It's from the state of Virginia, and the date on the license is 1990. Do you recall?
That's correct. I don't have the binder, but that's correct.
Okay. But Virginia requires medical doctors to obtain a new license every 2 years, like most places do. So this 19-year-old license would have expired back in 1992. Isn't that something that the IRB should have caught?
Since they weren't looking at that, I guess they wouldn't have caught it, but certainly if they understood that it had to be done every 2 years, that would be something that they could put in their protocols.
Well, Mr. Duber, how come the company did not catch the fact that this is an expired license? I'm a physician, so I'm very sensitive to issues relating to physicians. And
Right. I don't know. I wasn't there. I don't know why it wasn't caught.
But you would agree that if a doctor had engaged in malpractice or had lost their license, that it would be the job of the IRB or COAST in particular to check that?
After this experience, I would agree, yes.
And you would agree that if you realized that that license had expired 19 years before, that you would you have approved that study? If you had picked up that the license had expired or that the license has expired, just simply that?
That's speculating, but if someone submitted something like that and it had expired, we would do a lot of other things then to check into the validity of other things sent to us, which could end up resulting in us not taking on the study or
but a
not
person,
approving it.
the principal investigator not having a valid license would be a reason to not approve,
Yes.
wouldn't it?
Gentlewoman, would you yield on that point? I mean, this license was invalid on his face, was it not? You didn't have to check. It was invalid. 17 years old, 19 years old. So it was invalid. There was no checking to be done.
Yes, that's correct.
Okay.
My time has expired, Mr. Chair. Thank you.
Have any other questions?
I did have another one.
Go ahead.
Okay, to Dr. Less. In April of 2007, well before our investigation of COAST began, HHS received a letter containing allegations about COAST. They turned the letter over to FDA because the accusations related to FDA-related research. FDA initiated an inspection of COAST in July 2007. In March 2008, FDA issued a warning letter to COAST finding that Darren McDaniel, who was the CEO at the time, improperly assigned someone with only a high school education to conduct an expedited review of a human testing protocol. Dr. Less, I think it's commendable that FDA took action to investigate and address this allegation, but as the GAO investigation has shown, COAST had numerous other problems, including a review process that approves protocols based on a 19-year-old medical license, board members who don't read protocols, and the use of coupons that explicitly encourage IRB shopping. Why didn't FDA identify some of these other clear deficiencies at COAST?
Thank you. Congresswoman, FDA, when they go out and do an inspection, they generally spend a few days in site, and they pull 2 or 3 studies, follow those studies from approval through continuing review, look for adverse events, see whether or not the IRB had appropriately addressed those adverse events or changes to the protocol. When we went out on this, it was a for-complaint. We had already, a for-cause inspection. We had been out there several times before, had not identified problems. So for this case, we went out specifically to look into the allegations that expedited review had not been used properly. So we were investigating that, and we did issue a warning letter, and we imposed sanctions because we had been out there before and had found some minor violations, so we imposed sanctions that they not use expedited review anymore. And generally what we will do when we do issue a warning letter is follow up. We make sure that the IRB institutes a corrective action plan within 15 days. We review that, look to see if it had adequately addressed everything that we were concerned about, and then we put them on our list for follow-up inspection.
But, so you don't do a comprehensive review generally when you visit an IRB, you just review the specific complaint?
It depends on why we were out there, because we had been there several times before and had done a more comprehensive review and pulled a number of studies and looked at those other studies. But in this particular case, we just focused on the complaint.
But the original letter also identified other concerns, including backdating, changing board meeting minutes, and not following through with board requests. Did the FDA inspection investigate those issues while you were there?
We did look into all of those. The ones that we identified in our warning letter, I believe, were all related to the use of expedited review and potential conflict of interest that the CEO had inserted himself into the process and had inappropriately used expedited review. And so we focused on those issues.
Including the backdating, the changing of the board, you did? And Dr. Menikoff, did the set of allegations result in an evaluation of COSA internal practices and procedures?
You're talking about the current allegations?
No, the ones that I just referred to, the 19-year-old doing the expedited review and the backdating, changing board meeting minutes, not following through with board requests.
Well, Congresswoman, as noted earlier, OHRP and FDA have separate jurisdiction. They began this investigation on a study which was under FDA jurisdiction, was not under OHRP jurisdiction. FDA and OHRP regularly communicate, and we discuss issues relating to actions that one agency or the other takes, and we will deal appropriately and do generally deal appropriately in terms of this.
Well, I'm going to stop here, but my question really was, did you do an allegation as a result of those set of allegations? Did you do an evaluation?
The evaluation
related to this?
Was under FDA's jurisdiction at the time, and we would normally at that point, it's the same set of regulations, we would normally allow FDA to conduct an appropriate investigation.
Thank you, Mr. Chairman. I appreciate the additional time. Thank you.
Thank you. Mr. Duber, if we go back to that license that was 19 years old, if you could put that back up on the board, could also indicate that maybe the doctor had been malpractice, no longer licensed to practice medicine. Could it not if a license 19 years old?
It could have been anything. The fact that we didn't catch that it had expired was something we should have caught.
Right, right. Because, back, and the reason why we're doing these hearings, and I've been on this committee now for 15 years, and Mr. Walden for quite a while too. Back in 2002, we had a veteran die during experimental drug testing conducted by someone who was not credentialed to practice medicine in the United States, like this Jonathan Kruger technically is not, because his proof of license is 19 years old. So your responsibility as institutional review board is to do due diligence to protect the health and safety of the patient. You're the gatekeeper between medicine and the patient. And you testified earlier you had 4, I think you had 5. You have 4 doctors and 1 registered nurse and 2 other people in reviewing this. I'm baffled as to why there's no due diligence then and why things like this are not caught. If I had 4 doctors looking at a license, I think someone would have caught it. You might talk about 2.5% of our adhesive block, but 97.5% of it, we don't know what it is. And then you're going to put this in the lady's abdominal cavity, not by the doctor who performed the surgery, but by an assistant according to the protocol, and the doctor wouldn't even know. And if I was a patient and I became sick after you dumped this liter bottle in me, you know I'd go to the doctor, and the doctor who performed the surgery wouldn't know anything about it because the protocol was real specific that the doctor had to be out of the room when they applied the adhesive block gel to our patients. I would have thought someone, I'm not a doctor, but I thought that's pretty strange, isn't it? Because when I get sick, where am I going to go? I'm not going to go to the assistant who put the gel in me because I don't know who it is because I'm under anesthesia and I'm out. I'm going to go back to my doctor. My doctor isn't going to know anything about it according to this protocol. That's crazy, isn't it?
I spoke further with Dr. Dodd, and he told me that he was familiar with a product called Hiskin. He said it's a similar product used in surgeries and is added to the abdominal cavity in the same relative volumes as the protocol here. Dr. Dodd said he is very familiar with Hiskin and was comfortable with that volume. So
but you never verified the 510K process to see what this junk is I'm dumping in the woman's body. You never looked. Now, there might be something out there that maybe in the surgical field someone may use, but remember, you're the gatekeeper. You're the person who's protecting the patient from some doctor whose license is 19 years old, and you're the gatekeeper. So just because there's might be something out there, but since you don't know what 97.5 of this stuff is, you really can't say it's safe.
Well, that's precisely why, after having experienced this whole episode that we've gone through, we have changed our SOPs to check the 510K, to check on the predicate device that's based on, to check, the doctor's credentials, to check the existence of the company.
Well, what about the, you said you've done thousands of these trials. Currently, you're in 70 clinical trials. Did you do those in those others? Did you check the doctor's credentials? Did you check to see what the licensing regulations are, the 510K, whatever you call it?
We did not, and we have never had a fraud like this perpetrated on us. We've had all.
It's not a fraud on you. You didn't do your work. We caught you. That's all. It's not a fraud. Where's the fraud?
No, that's incorrect, sir. We did our job. We did what FDA regulations
Really?
require.
I thought you said your job was to do due diligence and protect the patient. How did you protect the patient in
We were
IRB
following
with
the
this
regulations
protocol?
that are outlined in the FDA's regulatory.
Sure. Does the FDA license say, regulation say you have to check the credentials of the doctor? No. Does it say you have to check the substance? You get paid.
We've never had to, sir, because we've never had anyone try to.
So what expertise do you have if you say now when you're caught, well, the FDA didn't tell me to do this, but the FDA doesn't tell you the basic stuff. So what's the expertise of your Coast IRB to even to review protocols? If you can't catch simple things like this, and if the FDA doesn't tell you, you can't think of it, what qualifications then do you have to be an IRB?
We have a great deal of qualifications. We've got some outstanding, very educated, very experienced doctors and nurses and lay people on our board.
Then why didn't they catch it? You had more medical people. I've looked at a lot of IRBs. Of the 7 people, 5 of the 7 have medical backgrounds. They never catch any of this stuff. That's amazing. Especially since our protocol, as testimony was earlier, Mr. Coons had indicated, is truly based on a real study of a product that killed people.
Our review procedure, well, this product wouldn't kill people, and we know that.
What?
Our procedures are.
Tell me, what's in this bottle? How do you know this won't kill anybody?
I'm not a scientist. I can't answer.
Well, you keep saying this product wouldn't kill anybody. Our adhesive block wouldn't kill anybody. You don't even know what's in it. See, that's a part that baffles us up here. You act like you did nothing wrong. It would not harm anybody, but you don't know what's in here. Isn't that your responsibility? Again, protect the patient. Isn't that your responsibility? How can you protect the patient if you don't know what's in it? I mean, the other 2 IRBs that we've spoke of and Mr. Coons have talked about, man, they just said this is crazy. You shouldn't do this. There's no patient safety. We don't know what the substance is. No one should do this. And then when they finally realized someone approved it, they said, oh boy, that was your famous quote, I think there, Mr. Coons.
We've had, Dr. Dodd was the original expert that reviewed this, and now we have this other outside party that reviewed it who's an expert. And
oh, wait, this outside party.
He said that
he reviewed, he reviewed as a block? My adhesive block?
Yes.
He reviewed this?
Yeah,
your expert there you mentioned.
Yeah, the expert reviewed that, yeah.
Oh, yeah. What's in here? What does your expert say is in here?
I don't have his report
Well,
in front.
you just paid for another bad report because no experts ever reviewed this. You know why? Because we made it up last night. There's 2.5%, little stuff on the top here. We made this up. So if you're expert, if you paid someone money to review this, they never contacted us to get what the contents we're talking about. How can you review something if you don't even know the chemical formula of the stuff you're supposed to be reviewing? Let me ask you this. Let me ask you something you should know something about. This is your coupon that Mr. Coons testified to that was delivered to him after you had your first contact with him. Where Coast, here's your coupon, good for a one-time research protocol review worth $1,300. Take a free test drive on us. And here's the back of your coupon. So let me ask you. Take a free test drive. There's a picture of the car and all that here, and there's your smiling face looking. Here's the car. Here's the smiley face looking at me in the rearview mirror in my car. And it says, coupon good for a one-time research protocol review worth $1,300. And then it says, coast through your next study. So it sounds like to me that your study is more likely to be approved if you go with Coast. Am I reading that wrong?
No. Yes, you are reading it wrong, because what that is a marketing piece. It's just trying to get different companies, new companies, to try out Coast and try out Coast's customer service. There's nothing wrong with using some kind of a promotion to gain new business. It
Sure.
Doesn't have anything to do, this is the business side of the business. This has nothing to do with the review board and the decisions they make.
Well,
Those are two separate businesses.
coast through your next study. We coasted through in 48 hours, and there are all kinds of problems with our study, right?
We're not using that marketing piece anymore, but yeah, that's just a piece that was used to try to generate some new business. It has nothing to do with the actual review of the studies. That's done by a separate review board that are independent contractors. And they have nothing to do with the business side. They don't know anything about money that we make or money that we don't make. They're not.
Well, speaking of money you make, you
about
made what, about gross $9.3 million last year, at $1,300 a pop. That's a heck of a lot of reviews.
Well,
And-
most of them are a lot more than that, because that's a single study rate. There are protocols that have hundreds of sites generate a lot more revenue because there's a lot more work involved to review it.
Sure. Let me ask you, FDA or HHS, how many institutional review boards come online every month?
Each month, we process about 300 applications. Some of those are amendments, renewals.
So basically, how many are new ones then a month?
I don't have an exact number on that.
Are you concerned that people are seeing this as sort of a quick way to get rich? I mean, do you need 300 a month? That's 3,600 a year.
Again, Mr. Chairman, many of those are likely to be amendments or renewals of an existing IRB.
Well, don't you think we should have some kind of limitations on IRBs? Shouldn't they have some qualifications before you become an IRB?
If you'd like me to address the registration system that OHRP runs was put into place as a result of the OIG 1998 report.
Yeah, but
The goals of the registration system were modest, to have a list of the number of IRBs out there and to have some contact information.
this is your registration system. This is Trooper Dog, remember? At Maryland House?
Mr. Chairman, the system is such that we verify that people put in information for a requested piece of information.
Really, how'd you verify it with Trooper
By
Dog here?
registering an IRB, the federal government is in no way endorsing that IRB or in any way saying that IRB
Don't you think,
meets any standard.
don't you think when an IRB is registered with the HHS, there's sort of like a seal of approval, I'm authentic because I have this approval, like fake medical devices, the one we sent up by Mr. April Fool?
Okay, Mr. Chairman, again, in no way, the system was not designed to be any endorsement of an IRB, nor do we intend it to be. And to the extent any of the evidence you revealed during this hearing or the GAO has
Yeah,
revealed.
but my question was, doesn't it
indicates
give people an air of authenticity because you
I
approved them?
understand that. We were not aware that this was a problem, that people out there were
Really?
thinking because an IRB was registered that the federal government was endorsing it. The federal government has many systems by which it has lists of, again, this is sort of like a phone book.
This is an IRB that's supposed to be set up to protect patient safety. This
No,
isn't a phone book.
I understand that. And there are many parts of the system that actually help ensure that IRBs are operating appropriately.
Tell me one thing you
registration
do
system-
after you register an IRB. What do you do to make sure they're valid IRBs and are doing it properly?
OHRP has several divisions that work at this. We have a compliance division that we accept reports of noncompliance from anybody who wants a report.
So nothing until somebody complains, like if someone dies.
If you're asking whether the current system basically puts a stamp of approval on an IRB at the moment it's created, it was not designed to do that.
Mr. Coons, what did your investigation find when people would register? Was that a seal of authenticity, approval, or something? Why did you undertake that part of registering fake IRBs with HHS?
Obviously, he's saying it's not intended to, but one of the IRBs, for example, that we submitted our protocols to, said that it gave us an era of legitimacy. And so, yes, I believe people out there would believe, and plus it's called assurance, but it's really self-assurance. And so it doesn't really provide anything except a registration, as he said, of what's in the system. So maybe we shouldn't be calling it assurance either, and it depends on how you perceive that. I could perceive assurance to mean someone's actually reviewed and approved an application.
But, Mr. Chairman, will you yield on this point? Because I thought the CFRs, the regulations of the federal government in 45 CFR Part 46.101D state that as part of the evaluating assurances, the department, quote, will take into consideration the adequacy of the proposed IRB in light of the anticipated scope of the institution's research. Is that not part of your rules?
Yes. Now, that rule dates back to 1974. It was implemented at a time when this whole system was first being created, and people didn't understand the complexity of how the system works, how you best protect research subjects, and how an IRB should function. Over the decades, as the system was implemented, people discovered, basically, that the efforts being spent in implementing that provision essentially amounted to verifying, for example, that an IRB that reviewed medical type studies had 1 or 2 doctors on it. And a lot of effort was being spent at assuring that fact. This was then reviewed by the OIG in the 1998 report I described, and it actually concluded that the way that provision was being implemented was not actually advancing human protections, that a better way to do this was to create a more streamlined system, that basically what you needed was...
And we are 10 years later, and that system's due to come online this summer?
No, parts of that system have already been implemented.
And so if you had to follow this regulation that's still on the books, correct?
Yes.
Would not that check of assurance to make sure that the fake IRB created by GAO was legitimate, wouldn't that regulation have caught that? Or I mean, these folks listed themselves as from a city in Arizona named Cheatsville. I mean, come on.
Okay.
Do we have nothing in place that would have caught a fake IRB?
Congressman, the system currently is designed in a way that you gave a registration with some cute names that, again, had spelling errors and other things that unless somebody sat there and tried to pronounce the names and the addresses, they would not pick up the things that seem incredibly obvious right now. And the system wasn't designed to do that. We do not have our staff going through the names to see whether people have put funny names on the list, nor indeed would we know what to do.
So what good is it to register with your agency when you put a stamp of approval on an IRB that then is system-wide usable for others to go through to certify human tests?
Congressman,
is it a pointless purpose?
We are not putting a stamp of approval on the IRB. If the
But
federal
people
government...
market it that way. We have examples of advertisement where they say, this one, I won't read you the name, you can count on IRB standard for high quality review and documentation, full AAHRPP accreditation, good standing with FDA, registered with OHRP.
Okay. And again, it is mentioning several other entities. One of those is AAHRPP, which is an accreditation entity that is in the business of accrediting IRBs. Well, but in terms of the federal government's aspects of this, we are not in the business currently. I mean, that would be a different system, and we welcome your input in terms of whether or not you think that would be a good thing to do. That would be a dramatic change from the system. The system was never designed to basically have us from the outset endorsing and putting some sort of stamp on approval.
So you think the system works well today?
Right now, we think we have a well-functioning system. There is certainly room for improvement, but in terms of the part of the system that OHRP deals with, it is interesting that GAO, for example, we deal with the HHS-funded studies. GAO was not able to create a fake study that went through and got federal funding.
No, but GAO could have created a study that, through private funding, that would have your HHS stamp of approval on an IRB, right?
Again, it is not a stamp of approval. It is a registration.
Well, you don't call it that, but you could say I'm registered with
To the extent
HHS.
you're indicating a problem, we welcome the information and we will look into this in terms of making sure that people out there know the government currently is not putting a stamp of approval. It is a registration list. Anybody could sign up on the list. That is exactly
Clearly.
what OAG intended when it asked for this list to be created. It wanted a quick and dirty way to put people on a list so we'd know vaguely how many IRBs are out there and contact information on them.
Mr. Coots?
Well, I think the federal-wide assurance, which includes the IRB and the medical device company, this is necessary for federally funded research. So it is, I assume, meaningful for federal people applying for federal grants with, I believe, 19 agencies. So I would believe those agencies potentially put some credibility behind people that have federal-wide assurance.
Because what you're getting when you register with Mr. Minikoff's office is federal-wide assurance.
Correct, for
That you're
federally funded projects.
For federally, that's the gate. You got to get through that gate in order to even go to the next step, right?
Correct.
And then there may be a check or balance that catches you there.
Could be beyond that, yeah, but just to get that, you have to get that to even apply, is my understanding.
So it does serve more than just a place to register to get mail for future conferences or other updates. It is actually something that is required elsewhere in the government.
For federally funded projects, not for privately funded. That's my understanding.
Do you disagree with that?
Okay, if I could clarify, we're talking about two things here. There is a registration system, which is a registry with a list of some information about each IRB. There is an assurance process, the federal-wide assurance. They are different things. The registration list, yes, an IRB to be used by an entity that wants to get federal funding or HHS funding has to be listed on the registration list. If I could describe the federal-wide assurance, that is essentially an agreement by which, before you take federal funding, you have to agree. You have to sign on the dotted line that your entity agrees to abide by the federal regulations. So essentially, by getting a federal-wide assurance, an entity is actually committing itself and putting itself under a legal burden that it will abide by the regulations. The federal government is in no way endorsing the entity, but it's just that a federal funding agency at HHS cannot give funds to that entity until it is basically sworn and said, yes, we will protect human subjects. We agree that we will have to abide by the federal regulations. That is a good thing, and the intent of the system was to make sure people could get federal-wide assurances and could basically be willing to swear that they will indeed abide by the federal regulations. But that is what the FWA does.
I guess when I get back home and try and explain how you register an IRB with whatever you want to call it, and it's up here on the chart, fake medical device, easy reviews. They are clever names, I don't doubt that. And that gives you then the authorization to oversee the protocols on a human test, and that seems to be all it takes.
If I could clarify, in terms of the jurisdiction side that OHRP deals with, a major part of the picture has been left out, which is that the IRB is not working in a vacuum. As we noted, again, GAO is actually not able to get federal funding.
Right.
An IRB reviewing a study, it is hard to get federal funding.
But they did get approval. On the other side of the coin, they were able to go to an IRB and get approval for human tests.
Yeah, and I'm just pointing out an IRB that is reviewing a study that's getting federal funding, getting federal funding itself involves a very detailed process of checks and balances that at least, again, that is a part of the research world that is under OHRP's jurisdiction. Much of the vetting that you're concerned about will actually happen. For example, before NIH gives funds. Barely 20% of the studies actually get funded these days. It is very competitive. These things are reviewed by panels of the most eminent experts in the world.
So you don't see that there's any real problem with this, what you've learned from GAO, is that?
Up to now, everything you've indicated GAO has done, I would think would be highly problematic for that to have happened in terms of the studies that get federal funding. Again, we're open to looking at the information and deciding what happens, but at the moment, I'm not aware of it.
We didn't apply for federal funding, so I'm not sure, and I don't think we necessarily would because we might actually displace a legitimate applicant, so that would not be necessarily an appropriate undercover test in this case, but we didn't apply, so I'm not sure if we couldn't, but we didn't apply, and I assume there's a lot of other controls there that would have had to have been tested, but just for the record, we did not try to get federal funding. We just used this to give us an air of credibility out there amongst the people that were medical device and IRB companies.
So wearing your fake IRB hat, you felt like you got that stamp of approval, and it meant something in the marketplace when you advertised.
We used it as that, and certainly, again, as I mentioned, at least one of the IRBs that we sent our protocols to said it gave us legitimacy. And I understand what the HHS witness is saying here, but that's the perception out there. So that's an important, you know, whether they like it or not, that's what the reality is out there amongst people. So,
all right. Thank you, Mr. Chairman. I know Dr. Burgess is.
Ms. Burgess, questions?
Thank you. Mr. Duber, let me just ask you, was this product ever used? Are there any patients who received this product?
No, not that I know of.
Well, I mean, the board approval came in October, the end of October.
The first approval did, and then November 6th, they approved the total project, including the ICF form.
But no patients had been enrolled? Is there any way to know that absolutely for certain?
No, we have not. We did not receive any SAEs or PD protocol deviations or anything of that sort, like a sponsor would be required to send us if there was a need to send that to us.
But say there wasn't any protocol deviation, say everything went just smooth as silk, would you know that a patient had or had not received the 4 250 milliliter vials of stuff?
Not until we did a continuing review, which the board set for 6 months later, which would be next month. Then we would have to go back and have resubmission to us of all the documents. It basically is a full review again of the protocol and the ICFs and whatnot.
Well, Mr. Chairman, I'm going to ask that information be made available to us, and I would hope it would be made available to us before a month from now. In light of everything that we've heard today, patient safety should be critical and uppermost in everyone's mind. If we've got people out there who've been treated with a product that wasn't even a real product.
Perhaps Mr. Coons could probably answer it.
That's a real issue.
There's no real patients. The whole thing was bogus. So there was no people signed up. Now, they could have been, but they weren't. There was no surgeries performed. Again, everything that we provided was fabricated.
And on March 6th, I might add that we convened the board of our company, and not knowing that this was still, not knowing what this was, we convened the board and rescinded approval for the study and notified the study sponsor of that, but never could get a hold of anyone on the phone or whatnot. And who we had to send it to was a post office box, so it was a phony site to begin with.
So there was no actual product
No.
produced, and I don't know where this
No.
looks like a big red
No.
up here, but where did
This was all a big setup.
We never actually mixed the product together, never, ourselves.
Okay. Now, the issue that was of concern to people about the 2.5% active ingredient, the propylene glycol, and then I guess 97.5% diluent, do we know, was that just a made-up stuff too? There was no actual diluent that was used in those 250 milliliter vials?
Correct. We didn't say what the other 97.5% was. Our protocols were silent on that.
Okay. I'll just point out that is unusual to pick a product up off the shelf and not know what the rest of it is, because the vehicle is important it is important to be aware of what the vehicle is. Let me just ask you this: if this had gone forward, if this had been a real fake product or whatever, who would have paid for the surgery? This is a product that could only be placed at the time of an operation, presumably an anesthetic, day surgery or hospitalization. All of that entails some cost. So to get to that point where you can actually administer the product, who was going to pay for the rest of everything else that was happening that day? Lab work, hospitalization, day surgery, surgeon's time, anesthesia time?
If I believe the way this was set up was that the patients were people that were going to have surgery anyway, and they would have had to have paid for that surgery through whatever means they had to pay it. They were not receiving any
Okay,
money.
let me just interrupt you on that thought. Would you have actively excluded a patient on the Medicaid system? We made a big deal about no federal funds were used, but would you have excluded a Medicaid patient from this protocol?
That would have been the sponsor's decision, and we wouldn't have had any involvement in that, so I don't know.
So there could have been federal funds used in the installation of this product
If it
in the
were
peritoneal cavity.
If it were real, and yeah, that could be the case.
Right. It's hard when you're dealing with a make-up world, and I do
Yes.
understand that, and I sympathize with you, but we shouldn't be here in the first place, so I'm going to press on. The second surgery, the second look operation 20 weeks later, so 6 months later, we're going to have another look to see whether or not our product worked. Who is going to pay for that surgery?
I'm not sure, sir. I don't know. I don't know.
I don't believe our protocol said. That was one of the questions we got from one of the other IRBs. Who's paying for the surgery? Who are the physicians? Who are the surgeons? Who are the people that are going to actually apply adhesive block to the women's pelvic area? That was all silent in our protocols. Those were serious questions we got from the other IRBs.
Well, I mean, it just struck me because that's not a normal course of events. You do a laparoscopy for pelvic pain, diagnose endometriosis. You're not necessarily going to be back in 20 weeks looking to see what things look like today. So that's a little bit of an unusual situation just from my recollection of clinical practice. I realize it's been a few years, but that would be a deviation. Someone has to pay for it. And again, my concern there is if we involve the Medicaid system, then again, federal dollars are used in this test protocol. So we can't really just say no federal funding was used, so we can't be interested. I think we should be interested from a patient safety standpoint, but there was a real possibility, had this not been a fake study, that federal funds might well have been used, depending upon the part of the country where the study was conducted. Because obviously we've heard on this committee time and time again about the greater and greater proportion of patients that are being covered by Medicare, given the state of the, Medicaid, given the state of the economy. Is there, and I'm not sure whether I need to address this to Dr. Meinkoff or Dr. Less, but here you had, albeit a make-believe company, and it got one positive response to several it sent out. Does anyone sort of take the 30,000-foot level look at this and say, wow, 2 IRBs turned this down in 1 bit? I wonder why it only had a 33% acceptance rate out there in the universe of IRBs. Would that trigger a red flag on anyone's part in any of the federal agencies that have oversight, not necessarily of the federal funding, but of the patient safety aspects?
Yes, I think it has a big bearing. With all due respect, I sit here, feeling troubled that only 3 were selected, and we were one of the 3. I mean, why not select 40 or 50 of them? I mean, why are, I understand where you're going, and I'm honestly, I have to say, I'm on your side. I want my company to do an excellent job of protecting human subjects. And of course, we have work to do. We are not perfect. No one is perfect. I'm
going to interrupt you in the interest of time because the chairman's going to cut me off. He always does, and I can't stop him. But Dr. Meinkoff or Dr. Less, is there any mechanism in place right now when you only have a 33% uptake rate that raises a red flag, that maybe this is a protocol that needs to be looked at more scrupulously?
Congressman, there is a check in place in our regulations in that when a study is for a medical device, when it's presented to an IRB, the IRB is supposed to make the determination of whether or not an IDE is needed. If the IRB disagrees with the sponsor who's presented it as a non-significant risk product, if the IRB decides it's not non-significant risk and it is in fact significant risk, the IRB is supposed to tell the sponsor that, and the sponsor is supposed to report it to FDA within 5 days. So there is that check in place. FDA would be notified if an IRB, as they were supposed to do, make a decision, and if they disagreed with the sponsor.
Did that happen in this make-believe world that we're in today? Did any of that occur?
No, that did not occur, to the best of my knowledge.
And I know I'm a little slow on this, but who should have picked that up? Where should that have occurred?
Well, the sponsor, who was fake, should have been reporting that to FDA.
And does the FDA have any mechanism in place to know that, oh my goodness, this sponsor did not make any sort of report at all? Well, we wonder why. There's some curiosity to go back and look and see why no report was made.
We wouldn't necessarily know if the sponsor did not comply with the requirement, did not make that report. We wouldn't necessarily know. If they did make the report, then we would go out and look at the study, decide whether or not we agreed with the IRB, or the sponsor decide whether or not it did in fact need an IDE.
So there's no way to track, I'll just call them dropped cases for want of a better word. If the investigations that just don't come back to you, then you don't know why they weren't pursued.
Well, what could have actually happened if there were a real case, if a sponsor goes to an IRB, says my product is low risk, the sponsor says no, in fact that is actually high risk, that sponsor then could not conduct the trial. They would make the report to us. They would not be able to start the trial. If they went, and so there is that check in place that they would be reporting to us.
But what if they were venue shopping on this and went to several IRBs simultaneously as the fake company did?
Well, hopefully when they went to the second IRB, they wouldn't lie and say that it's still a low-risk product. They would fix their protocol or go in and say this is a significant risk product. Because again, that second IRB would have to ask the sponsor of the trial, is this significant risk? Does it require an IDE? The product could not be shipped and the study couldn't be started without our approval too for this kind of product. So there is that second check in place that the trial could never have gotten or should never have gotten started without coming to FDA.
Is that, Mr. Gibbs, is that what you're finding as well?
We said it was significant risk, and for the one IRB, we provided a 510K, which would have been a prior marketing approval. But no, we said it was significant risk. We did not say it was low risk.
So should the FDA have picked up on that fact and gotten back to you and said, hold the phone?
We never contacted the FDA.
Oh, you did not?
No.
But in the real world, it would be your obligation as an investigational company to contact the FDA.
I'm not aware of the regulations on that.
Right, but he was a GAO in charge of the fake company. So
Right.
you were CEO of a fake company. If you were a CEO of a real company, would that have been the obligation of the real company to do that?
FDA knows the answer. I don't know the answer to that.
I need a yes or no, or the chairman's going to whack me.
Yes, the fake company, the fake company should have reported to FDA that the product was determined to be significant risk. These types of products are on we have a guidance document that lists significant, non-significant risk products. This type of product is listed as significant risk.
But it's all voluntary at this point. No one is required to do that. So if somebody's slipping under the radar a time or two, we've really got no way to go back and do any sort of internal check on that. I mean, I would be interested if I were at the FDA today, are there any others that have slipped under our radar like this? How many other bad studies have we missed?
It's not voluntary. It is mandatory that the sponsor report to us within 5 days if the IRB tells them that a product that they presented to them as being low risk is significant risk.
What penalty might they invoke if they don't report?
If they don't report, we would go after them. We could issue a warning letter. We would go out and inspect, issue a warning letter.
What if you found that federal funds were used, such as in the Medicaid or S-chip system? Would HHS become involved at that?
Last one, Mr. Baird, just we were more generous for
Okay.
our time. We got another member waiting.
All right. Would if the federal funds were used to pay for the surgeries or the procedures, Dr. Meinkoff, would that get your interest?
When you're referring to federal funds being used, the general sense of that is basically that the funding for the study taking place, in other words, an investigator is funded by NIH or CDC or FDA itself may be running a study. Normally, probably the fact that one of the procedures is paid through Medicaid, for example, it wouldn't implicate that. The key is that somebody in getting federal funds to run one of these studies, if this study was done with NIH money, GAO, again, didn't fully respond, but the odds are extraordinarily low that any of this could have happened, because in getting those funds, the legitimacy of this entity would have been vetted this way and that. You would have had top scientists asking, who is this person? What knowledge does he have to do this? Is he a well-trained physician? What papers has he written? Many parts of the system work together, and particularly on the HHS-funded side, to make sure that we have legitimate things happening, and this information then works together with the IRB in terms of making sure that there are substantial protections in place. So again, the facts do speak for themselves. GAO didn't end up producing a fake federally funded study. I think it would have been very difficult to do that. There are many protections in place.
And yet still federal funds could have been put at
Hey, Mr. Burgess, I really do have to know sincerely. Mr. Markey's been waiting patiently. You're more than 7 minutes over, so I'm sorry.
Thank you,
Mr.
Chairman, very much. Mr. Dubner, based on the review that your company conducted here, Would you have been comfortable with your wife or your mother being treated in her abdomen with the solution your company approved?
I can't answer that. I do not know.
You don't know if you would be comfortable recommending for your wife and mother something that you've recommended for all of these other?
It's speculating. I'd have to, I don't know. I mean, the doctor that I talked to that was on our board that approved this does this surgery, uses a similar product. He felt it was safe. We've had it reviewed by an expert, outside expert, and he says it's safe. I mean, the ingredients that supposedly were in it are supposed to be, the active ingredients are supposed to be safe. The inactive ingredients have no interference with the effectiveness of the active ingredients. So absent any other information to prove them wrong, I guess if I were in a decision-making mode, I would probably say yes, go ahead and use it on them. But of course, that's their decision, not mine.
Right. Well, if you look at your record, the committee requested information on all of your reviews for the past 5 years, and this is what you provided, that your company reviewed a total of 356 proposals for human testing, and you approved all of them. So that means you approved 100% of all the studies that you reviewed.
I'm not sure the numbers you're looking at, 356, what?
You approved 356 protocols were approved, and the board voted
for what time period? I'm sorry.
Over a 5-year period.
No, we've approved more studies than that, sir.
These are the records that you submitted to the committee, and I'm working off of your documents that you provided to us.
I believe you may be looking at the audit numbers that we sent to you.
We have you've provided to us every vote which the board cast over the last 5 years. And of the 356 protocols, you approved every single one of them. 7-0 on each vote, except on one occasion when one single board member dissented. So that means out of 2,492 votes cast by board members, all but one were in favor of approval.
We have been requested to provide you with a list of all of our protocols since the inception of COAST and which ones were approved, which ones were not approved, and we will work on that and send that information to you. I can tell you that we do audit a fair number of protocols. In the last 3 years, we've done about 50 to 60 audits, and some of those audits, we have overturned the original ruling of the original approval of those studies.
Well, Mr. Coots, let me read to you from their website. Here's what it says. It says, COAST IRB's quick document turnaround will save you valuable time and ensure that you can seamlessly move on to the next steps quickly and efficiently. Our superior service guarantees your site approval documents will be sent to you the next day following every board meeting. In this case, do you believe that emphasis on speed contributed to the company's failure to conduct even cursory due diligence, which, if it had been done by the firm, would have been as a result of a basic documentation review, found that there was ultimately a fictitious nature to this entire enterprise?
The answer is probably yes. And, one of the reasons we picked the 3 we picked were because they appeared to have the less stringent documentation requirements. That's why we picked them. So we were testing the system, but we were picking ones that we thought would have the less stringent paperwork requirements. And in fact, as I mentioned also, the other thing that this IRB was selected is because they offered us a coupon.
Yeah, well, I think that it's pretty clear that I know Mr. Dubner doesn't see it that way at this particular point in time, but I think the GAO and this subcommittee are providing a real service to your company. Sir, I think that we're trying to help to protect against such a lackadaisical system harming human beings. And you seem to be outraged, actually, at our pointing out this deficiency in the way in which your company conducts business. I just think it's important for you, sir, to reconcile yourself to this as an intervention in underlying corporate pathology, and that we're trying to help you to correct your business practice so that the public is protected. I know you don't see it that way right now, but I think when you look back years from now, you'll see it that way. And I just think that perhaps now you're being advised by counsel to take the position which you are taking in your testimony here today, but it's not helpful to you to be denying the obvious, which the GAO and our subcommittee chairman have identified. And that's my advice to you. Try to start out where you're going to be forced to wind up anyway. It's going to be a lot prettier. Okay, this testimony that you're delivering today is not helpful to yourself or to the cause of ensuring that there are real processes that, protect the public. Thank you, Mr. Chairman.
Thank you, Mr. Markey. A couple questions I want to ask, follow up to Mr. Burgess, and I think Mr. Walden hit on it too. On IRB shopping, this is a practice in which researchers shop their protocol around to different IRBs until they get an approval. In 2002, the previous administration considered issuing regulations to require researchers to disclose prior IRB decisions so people would know if the study had been rejected in the past. On January 17, 2006, the previous administration withdrew this proposal, concluding that IRB shopping does not occur or does not present a problem to an extent that would warrant rulemaking at this time. So 4 years later, they withdraw it. According to this decision, the administration apparently felt they had no reason to believe IRB shopping was occurring with any regularity. Dr. Less, that came out of the FDA. Who would have made that decision in the FDA? Would it have been the FDA, HHS, the administration? Who would have made that decision to withdraw this forum shopping, IRB shopping requirement?
Mr. Chairman, after we issued the advance notice of proposed rulemaking, we evaluated all of the comments that received. We had a working group involving experts from across the agency, including our Office of Chief Counsel, all of the centers, and we looked at the comments and made that decision based on the information that we received and also in light of current regulations and the protections that we think that our regulations offer.
So you asked IRBs and they said, no, we don't do that?
No, we put it out for public comment, and we got 55 comments. We reviewed all of those very carefully. We looked back at the IG report, which said that they were aware of a few cases of IRB shopping. In the comments that we received, we also didn't have any real reason to believe that there was any concern over IRB shopping. There are a number of reasons why companies will go to multiple IRBs for legitimate reasons. Sometimes a company will go to more than one IRB at the same time simply to get their study up and running more quickly. That doesn't necessarily mean they're shopping for the fastest or the least stringent IRB. We also we were concerned with the burden that it would put on IRBs in the sense that if you had a study with multiple sites, say 10, 20, 40 sites, if all of those IRBs had to share previous reviews, we felt it could overwhelm the system. And without knowing the other IRB's review practices, you would have no basis for deciding on the merit of that review. So, and we've seen that as an instance with, say, adverse event reporting.
So when, Mr. Dolber, let me ask you this. We asked you about, when you were interviewed last week by the committee staff, you disagreed. You said that IRB shopping, and I quote, in fact, if you want to look at your testimony in front of Dr. Meinikoff there on page 83, I believe it is. It has a green tab on it there. When asked about IRB shopping, you said, quote, has been a problem of IRBs, I understand, for quite some time. So IRB shopping's a concern then, right, amongst IRBs, that they're going to go get a bad decision for one IRB, so they'll go to another IRB until they get it? That's a problem? I'm sorry.
Sorry. From my perspective and my company's perspective, it is a problem. And
then answer me this. This is your coupon that you gave out to Mr. Coons. On the bottom of the coupon, it says, and I'm going to read directly now, it says, Coast IRB's free test drive offers applies towards initial protocol, informed consent form, and investigators drug brochure reviews only. $1,300 value. Coast IRB, LLC, pledges to protect the full confidentiality of all research studies sent to us for review. In 2005, the FDA removed the guidance prohibiting IRB shopping. As such, you are free to use our free test drive offer to compare Coast services with another IRB's concurrently. If, after comparing our services to those of another IRB, you choose not to continue with Coast IRB, we will destroy all documentation we have on file associated with your study. Neither your money, research time, or confidentiality will ever be at risk. Sounds like to me you're encouraging with this free coupon, IRB shopping, the practice that you say you're against.
that, sir, that marketing piece was created before I arrived at Coast, and we're no longer using that for that particular reason. But, you know, our position is that, and the company's position has been that IRB shopping is a problem, and there needs to be some kind of a database that everyone can refer to see if someone has submitted a sponsor has submitted a protocol to some IRB, and we can other IRBs can check that before we approve a study. Because
do you think there should be a ban on IRB shopping, and that if a study is rejected, it should be sent to the FDA?
I think it's the last part, probably, yeah. But we're in favor of improving the system and making it more difficult for people to do that, because obviously that's not healthy.
Right. Mr. Coons, under current law, if you had been a real company, you would have been allowed to ignore these 2 rejections you received and continue with your approval from Coast, isn't that right?
I believe so. And actually, one thing I want to mention on the shopping, in our initial emails to the IRBs we sent this to, we said very specifically that we were shopping for an IRB.
Okay. So they all knew you were shopping, your IRB shopping.
That's what our email said, yes. And
Okay.
I think you have those emails from the requests you got from the IRBs.
Okay. And after you got the approval from Coast, could you have begun your experimental testing on human beings? Would there have been any other steps in the FDA or HHS review before you started your experimental tests on real people and putting our fluid here, our liter bottle of adhesive block in the pelvic abdominal cavity of women?
As was mentioned, because there's no federal dollars associated with it, my understanding is yes.
Thank you. Mr. Burgess, I know you always have questions.
Mr. Chairman, if I could
Sure.
just clarify, that study should not have been started. It was a significant risk product. It would have required approval from FDA, so the sponsor should never have started the study without coming to FDA.
Who shouldn't have come to the studies for FDA?
The sponsor. The sponsor would go to the IRB, get IRB approval, and they also would be required to get FDA approval before that study could start and before any product could be shipped. So the sponsor...
What's the requirement to do that?
Pardon me?
What was the requirement to do that? I got my protocol approved. I got my consent form approved.
Mm-hmm.
So why would I have to go to the FDA?
Under the IDE regulations, investigational device exemption regulations at 21 CFR Part 812, for a significant risk product, which this is, the sponsor would be required to get both FDA and IRB approval before he ships the product or starts the trial.
And that's because Mr. Kuntz misrepresented. But what if it was some other product already approved? There was no requirement to go to the FDA? Because we had a, 510K there, right?
We faked the
Yeah.
510K.
Yeah, no, we had a 510K, so we don't have to go to the FDA in this one. He could have started on real patients if it was a real one.
Well, hopefully the sponsor, if it was a real sponsor, would have understood that this product is not subject to 510K.
And what do you do to make sure
subject
a
to
real
510K.
sponsor does that?
A real sponsor is supposed to come to FDA. We
I
have
know.
a
There's a lot of
pre-IDE.
assumption in these laws, aren't there, that people are being above board, and we
Well,
prove
actually,
today they're not.
Actually, we have a number of programs in place where sponsors can come to FDA, ask if they need an IND or IDE. We have a pre-IDE process where they can submit a pre-IDE to us, have us look at the protocol, look at the device, look at the testing that they've done to see whether or not it needs an IDE.
With all due respect, FDA hasn't been doing their job. That's why we're having this hearing, because when we did Copernicus study 3014, which there was criminal fraud, and your own CID asked FDA to do criminal charges against Copernicus, and the doctors who were doing this, FDA refused to do it. He rejected it. So there's very little faith on this side of the dais that FDA is doing it right. So when we suppose people are going to do it, and we suppose the FDA is going to do their job, we know what the end results are. Unfortunately, people die. So I'll go to Mr. Burgess.
Mr. Coos, let me just ask you, my understanding is you based this fictitious product on another product that actually existed but didn't have a good track record, is that correct?
We got it on the internet off of FDA's website, and then we substantially altered the entire thing. We used it really just so we had a format. We didn't know what a protocol actually was supposed to look like, so we got one just so we could know what it looked like, and then we changed it completely, and then we actually made up the ingredients. And
how many FDA protocols did you have to look at before you found one that struck you as a good one to proceed?
We just wanted one. I don't know if there were any more or not. We just found one on the internet, and that once we found that, we just used the format. Again, we didn't use the actual details of it. We created our own, but it showed us what one looked like. Was it hard to find one that that led you in the right direction? Yeah, I don't think there were a lot of them out there. Okay. What, Dr. Less, Dr. Meinkoff, I'm assuming that the Inspector General at HHS has been notified of this situation. Is that correct? I mean, does HHS have? No, we've referred this to FDA's investigators. Okay. That's the letter we've sent. Will it at some point go to HHS-IG? No, we plan to refer it to the FDA, and we've talked to the investigators that work under Dr. Less in her area. Had there been Medicaid funds used on any patient who received this compound inappropriately, would that have triggered HHS's involvement?
I don't believe so. Again, the HHS jurisdiction that OHRP has relates to there being a funding agency for the study. So basically NIH or CDC. Or
CMS.
Excuse me?
Or CMS.
CMS could act as a funding agency for the study. The fact that one patient in this study got paid, and I don't know.
But we heard testimony by Mr. Duber that the funding for the study was going to come from the third-party coverage of the patient, essentially. Perhaps there was no charge for the study protocol or the protocol drug, but there's a substantial amount of activity that has to occur to get to the place where the drug is administered, and all of that activity was presumably going to be paid for by a third-party payer. So in a way, CMS would have been funding this study had it proceeded, if Medicaid patients had been enrolled, or SCHIP patients.
My understanding is that is not the way in which something becomes HHS funded in terms of OHRP's jurisdiction. The basic issue is, has somebody applied for a grant from an HHS grant-making agency, and they then approved this? I mean, that is the protection and is actually a very strong protection. Again, this would not have happened if somebody tried to get HHS funding. I think it's extraordinarily unlikely, and people who are enrolling in HHS-funded studies should actually be relatively confident that
this whole deal is extremely unlikely, and yet we find ourselves here in a parallel universe that the GAO made for us, and now we're having to try to pick our way through it. I just find it. I personally find it unbelievable that HHS is not more interested in the fact that funding sources could have been diverted into a bogus study, and the patient required to have a second look procedure 20 weeks later. I mean, this is a big dollar item that we're talking about, 50 patients receiving a second look laparoscopy. No way to know how many of those would have been Medicaid, but that's a significant expenditure.
Congressman, I mean, it sounds as if you're talking about a use of federal funds for an inappropriate purpose. That is, I don't know what unit of HHS would deal with that, basically. OHRP is dealing with the human subjects protections aspects of it, not misappropriation of federal funds or misuse of federal funds in some way.
Well, Mr.
I really
Coots,
couldn't comment on what part of HHS does deal with that.
well, give us some comfort. Now, what are the next steps that are going to be taken here? Clearly, there are things that need to be improved, but are there some enforcement steps that are going to be taken? What happens next?
Only with respect to the one referral. I mean, I think the bigger picture is that you had this set of protocols that went to 3 IRBs, and you got 2 completely different answers at the same time. That's the part I think that should concern the subcommittee here. That on the one hand, 2 IRBs said this was a ridiculous protocol, unsafe to patients, should have never been approved. Another one is still testifying as we speak that it was perfectly safe. It's hard to believe you could have that divergent of a situation, and that raises questions to me about the whole IRB system, especially the private IRB system.
And Dr. Less, would you concur that from FDA's perspective that there's reason to be concerned about the whole system?
No, sir, I would not. I think under this circumstance, from what I've heard, this product was a significant risk product. It should have been submitted to FDA for review. The study would not start without FDA and IRB review. And in this case, there would have been that safeguard in place with having both the IRB approval and FDA approval needed before any patients could be put at risk or the study could have even started.
So any enforcement activity would be directed toward a company that doesn't exist and was made up by the GAO. Would any enforcement activity be directed in Coastal's direction for proceeding with a study with tenuous underpinnings?
Without seeing the report, I can't comment on that, but in general, FDA has taken action when an IRB has failed to make the determinations that it is supposed to make, meaning the non-significant, significant risk determination, and looking to see whether an IDE is required for the study.
Okay, well, so what will happen? What would that action be?
We would go out and do an inspection of the IRB, look at their studies, their processes, see whether there are other studies that perhaps the wrong decision was made, and if we found a problem, we would issue a warning letter. We could impose sanctions, and then we would see if they put a corrective action plan in place to take care of that. If not, then we could pursue other activities.
Do you ever make a silent pact with yourself that we'll never use this IRB again? Do you keep a list? Is there a watch list?
Well, there is all of our warning letters are public. They're on the website, so any sponsor doing a study should be looking at that website to see.
Is there any way to know that one side's talking to the other on this? Because this seems to be one of the problems we've encountered today. You had 2 say this is a bad deal, 1 said it's okay, nobody talks about it, so we go forward, or potentially could have gone forward with a very, very difficult study from the standpoint of the patient.
Well, warning letters are public. IRBs are obviously not happy to receive those. They take them very seriously and do submit corrective actions. We require that they submit a corrective action plan within 15 days if we issue a warning letter, and we do follow up to make sure that those corrective actions are taken.
Well, now, Coastal had on its website, on the Q&A, have you ever been investigated by the FDA? And they said, well, they had, but they got a commendation. But in fact, that wasn't accurate, as I understand now. Is that correct?
I have not seen the information on their website. I'm sorry, Congressman.
Okay, this is, again, a printout of Coastal's website. Do we have that to project? Under the frequently asked questions.
Coastal's website, do you have it? No, they don't.
Under the frequently asked questions section, have you ever been audited by the FDA? Answer, December 15, 17, 2003, Coast IRB was selected for a routine surveillance inspection. We received a commendation from the FDA investigators regarding the thorough and effective oversight provided by our IRB operations. A follow-up audit was conducted in 2005, at which time no further action was required by the FDA investigator. Do you think that's a true statement?
We inspected Coast 4 times. The first 3 times we did issue letters saying that voluntary action was indicated, meaning that we found minor deviations from the regulations, and we asked them to address. In the letter, we pointed out what those deviations were, pointed them to the appropriate regulation or guidance. They did submit a letter back to us stating that they had taken care of the issues that we addressed in each of those 3 letters.
Were those warning letters? Would those be the equivalent of warning letters?
No, they did not rise to the level of a warning letter. They were what we call voluntary action indicated. We have no action indicated, voluntary action, and then official action, which is the warning letter level.
And have they ever received a warning letter?
Yes, their most recent inspection that we conducted in 2007, we issued a warning letter to the IRB.
But we had this approval in October of 2008 by the board, so presumably they were under a warning when this study was, proposed study was to be undertaken. Is that correct?
We had issued a warning letter, and they submitted a corrective action plan, told us that they had put training in place for their staff, and were testing their staff on the conduct under the regulations of what would be required. And so we had reviewed all of that information. They had also, I believe, hired an outside consultant that was also supposed to be overlooking their processes.
Is that the basis on which you gave them a commendation?
We don't give accommodations to anyone, Congressman.
So,
In addition to that, Congressman,
but that's a misleading statement on your website, then, isn't it? If they don't, she says you don't get, FDA doesn't give a commendation.
well,
you say,
they sent us a letter reinstating our use of expedited review. We had given them a corrective action plan, and acted very swiftly. In addition to that, our CEO at
okay, I'm
the
going to
time
interrupt you because I'm
resigned.
going to get cut off again. If you'd be good enough to provide that letter to the committee, we'd very much like to.
The committee already has that letter. We provided that
perhaps
with
staff can make that
the
available, too.
package of materials we sent.
Thank you, Mr. Chairman. I'll yield back in the interest of time.
Thanks, Mr. Burgess. Dr. Less, you said earlier that warning letters are more serious violations, and in fact, the FDA issued a warning letter on March 11, 2008 to Coast for 3 different parts on expediting review of IRBs. Isn't that correct?
Yes, sir, that is correct.
And then now Mr. Kuntz has sent a letter about this situation and how Coast had reviewed this IRB or this protocol. So will the FDA now invoke a more severe penalty then on Coast? You already have a warning letter sitting there in their file. Now you got another allegation of wrongdoing. What will FDA action be?
Congressman, we'll need to take all of that information into account and do a thorough evaluation. Normally, if we issue one warning letter, the next warning letter would include sanctions, and we would take more serious action. But without knowing the specifics and having reviewed the entire case, I can't comment on this particular one.
All right, Mr. Dober, let me ask you this now. Wrap up this hearing here. Are all of the 7 people who approved this protocol, the bogus protocol, do they still work for Coast?
Yes, they do.
Okay. Has anyone at Coast lost their job because of their failure to adequately review this protocol?
One individual is leaving the company shortly.
But not as discipline action for this matter, right?
No, sir.
Okay, and how about the chair of the Institutional Review Board here? You're chair of this board that reviewed this protocol. She's indicated she didn't even read the protocol. Is she still working for you, and she's still a member of their company?
Yes, she is. We evaluate our board members once a year.
Okay. You've said a couple of times that you've changed your SOP, I take it as standard operating procedure review process, right?
Right.
So it sounds like a lot of good changes have been implemented then.
Yes, that's correct.
So a lot of good actually has come from being caught here on this bogus
Yes,
protocol.
it has, and I might add that during our lunch break, I talked to Dr. Less, and I basically pleaded with her to bring FDA into my company and do a full top-down, front-to-back audit of our company, because since I started with the company, I've done nothing but try to make sure that the company does exactly what it should be doing and do the best it can of any IRB.
And in all fairness, you've been there since December of 2008, right? Basically 4 or 5 months?
I started end of September, correct?
September?
And my track record is totally opposite of what we're talking about here. So I need time to improve things, and we are improving. We've got an incredibly dedicated staff, more so than I've ever seen in any company I've worked for before, that they really, everyone, their first thing that they worry about is protection of human subjects.
Then how'd they miss this one so bad? I guess that's the part that baffles us.
Well, we got hoodwinked. I mean, you know, this was a pretty good.
Oh, you didn't get
job by
hoodwinked.
the
You took
GAO.
the bait, hook, line, and sinker, man. I mean, in your testimony, in all fairness, you said that once you got the letters, you started looking at it, it took it seconds to figure out that something was wrong here. I think it was the doctor's credentialing that was 19 years old. It took you only seconds to do that just by going on the internet. The procedure that we use, our magic elixir here, is actually found on the internet. All this could have been discovered with a little due diligence. And
Well, and, you know.
well, hopefully, I'm glad to hear some good things have come from all this whole thing at Coast. So
Definitely.
I want to thank you all for coming here and thank you for your testimony today. That concludes all questioning. I want to thank all of our witnesses for coming. The rules of the committee provide that members have 10 days to submit additional questions for the record. I'm sure there'll be some. I ask unanimous consent that the contents of our document binder on the desk there be entered in the record, provided that the committee staff may redact any information that is business proprietary, relates to privacy concerns, or law enforcement sensitive. Without objection, the documents will be entered in the record. This concludes our hearing. The meeting of the subcommittee is adjourned.